for the following relief. The learned counsel for the petitioner has submitted that the father of the petitioner was a 4th grade employee employed with Krishi Utpadan Bajar Samiti, and while
Pardon?
yes,
I want to withdraw this.
after some arguments, the learned counsel for the petitioner seeks permission to withdraw this petition. Prayer quote करके district petition is dismissed as withdrawn.
Liberty may be given to for
No
the person in
liberty.
this case.
No liberty can be given.
साइन कर दीजिए.
You have to put your signature. You are advocate on record. You have taken instructions.
Yeah.
Yes. Instructions from
From Mr. Pankaj.
under instructions of Mr. Pankaj Srivastav, advocate on record. Put your signature, please.
For final disclosure, item 1, WPS 393 of 2023, along with item 2.
We are shift. The judgment passed by the honorables by this court in WPS number 7179 of 2011, within that is Dinesh Chandra Mehta versus State of Jharkhand. The grievance of the petitioner was that he was not granted promotion to he was not granted IA and BA trained scale and was also not granted promotion to the post of headmaster. But his juniors were granted the scale and promotion to the headmaster. In the said case, he had filed a writ petition before this court being CWJC number 3986 of 1999 within the Qatar, and by order dated 23/7/2001, a direction An order was passed for grant of IA and BA train scale from the date juniors to the petitioner were granted the said scale, and for consideration of his case for promotion to the post of headmaster from the date juniors to him were granted promotion, were promoted. After filing contempt, the respondents were pleased to grant IA and BA train scale and also scale of headmaster with effect from 1/3/1983, 4/3/1987 and 1/5/1990 respectively. That is from the date juniors to the petitioner were granted promotion and also the benefits of train scale. The grievance of the petitioner was that although he was promoted, but he was denied the monetary benefit of the train scale and that of the headmaster. From the date of joining the promotional post, but not from retrospective date from which the juniors to him were considered and granted promotion. The respondents had rejected his claim on the ground by referring to Rule 58 of Jharkhand Service Code and Rule 74 of Jharkhand Financial Rules, and were of the view that the petitioner was not entitled for monetary benefit from retrospective date. This court considered the judgments reported passed in the case of Dr. Paras Nagprasad Supra and also in the case of Ranjit Sahai Jamuar Supra, and this court considered the judgment passed in the case of Dr. Paras Nagprasad Supra and set aside the impugned order in the writ petition. This court finds that in the case of Dinesh Chandra Mehta, the petitioner was granted the relief from the date his juniors were promoted or granted the relief, and not from the date he was otherwise entitled for any revised scale, any promotion. The said judgment was subject matter of challenge in NPA number 211 of 2019, and the appeal was dismissed while judgment dated 19th of May 2020 and with regard to in the following manner, para 24 and 25. Para 24 and 25 of the aforesaid judgment is quoted as well. Thus, the claim of the writ petitioner in WPS number 7179 of 2011, that that is Dinesh Chandra Mehto, to get benefit of promotion with to get monetary benefit arising out of promotion to the post of headmaster was ultimately granted from the date his juniors were promoted. So far as the judgment passed in the case of Dr. Parasnath Prasad Supra is concerned, in the said case also, the relief was granted to the writ petitioner in the said case also, the grievance of the petitioner was that he was entitled to be posted next. He was entitled to be posted next below his immediate senior, and the matter was initially contested in a suit. The suit was decreed in his favor. The appeal and the decree in the suit attained finality up till Honorable Supreme Court. But still, and ultimately he was granted some benefit, but monetary benefit was denied to him by referring to Rule 58 of the Bihar Service Code and 74 of the Financial Rules. 74 नहीं था, कोई और circular था, and other circulars issued by the state government. And in the meantime, the writ petitioner had retired. In the background that, in spite of appropriate decree passed in his favor, and he was entitled to be placed immediately below his, entitled to be posted next below his immediate senior, he was not granted the consequential benefits. In the said background, the court held that the Rule 58 of Bihar Service Code and the circulars would not come to the rescue of the respondent state to deny the benefits which was conferred upon him by virtue of the decree passed by the civil court, affirmed up till the Honorable Supreme Court. In the said case also, the grievance of the petitioner was that he was discriminated against other persons and he was not given proper placement in the gradation list, due to which he suffered in terms of salary as well as promotion was denied to him and his juniors were placed higher than him. In the aforesaid judgments, particularly in the case of Dinesh Chandra Mehto, and also particularly in the case of Dinesh Chandra Mehto, the petitioner was held entitled for the relief from the date his juniors were granted one or the other relief by way of promotion, etc. In the present case, it is not the case of the petitioner that any of his juniors have been promoted and the petitioner has been left out. The petitioner is seeking promotion, and the petitioner has been granted promotion, and the petitioners are seeking petitioners have been granted promotion with retrospective date notionally, and they are seeking the benefit of the monetary benefit out of such promotion. In the judgment passed by the Honorable Supreme Court, in the case of Union of India versus Manpreet Singh Poonam, etc., dated 8th of March 2022, passed in Civil Appeal number 517-518 of 2017. It has been specifically observed in paragraph 7 that there is no vested or accrued right over a promotional post in absence of any vacancies actually in existence. And in paragraph 18, it has been observed that a mere existence of vacancy per se does not create a right in favor of an employee for retrospective promotion when vacancies in the promotional post is specifically provided under the rules. And in paragraph 19, it has been held that in the judgment passed by the Honorable Supreme Court reported in 1989, supplementary with the bracket 2 SSC 625, it has been clearly laid down that promotion to a post should only be granted from the date of promotion and not from the date on which the vacancy has arisen. The aforesaid principles of law in connection with promotion are well settled and has been clearly spelled out by the Honorable Supreme Court in the aforesaid judgment. However, with regard to the promotion of the teachers, a decision has been taken dated 26/8/2021 in the case of Dinesh Chandra Mehto. He was also governed by the same rules by which the present petitioners are governed.
That governs with the old rule.
Right.
93 will not apply in their case because it is coming from 1993. Their promotion from the old rule.
But they are also teachers.
Teachers. IA trained, BA
That's it.
trained.
Right. In the case of Dinesh Chandra Mehto also, he was his promotion. He was also a teacher and was claiming promotion. A decision in the present case, a specific decision has been taken by the state, which is dated 26/8/2021, wherein it has been observed that the matter regarding that there were numerous litigation in connection with promotion of the teachers under the 1993 rules as well as the law as it existed prior to that. And there was a litigation in connection with the grant of promotion in connection with grant of grade 1 scale which was subject matter of consideration in अरुण कुमार सिन्हा का जजमेंट का साइटेशन क्या था? अरुण कुमार सिन्हा
638 of 2006. What?
638 of WPS number 638 of 2006, and ultimately the matter settled up till the Honorable Supreme Court. And it was proposed that and ultimately an order was issued that except for the assistant teachers appointed in 1994, 99 and 2000, the rest of the teachers will be given notional pay scale and not actual payment. Yes, sir. But not actual payment. And in WPS number 7392 of 2017, it was observed that the benefit has been extended to all the teachers except the teachers of Bokaro, Jamshedpur, Dumka and Chaibasa, and the stand of the respondents was discriminatory and in complete violation of Article 14, and consequently a direction was issued to the respondents to take a uniform decision for extending the actual benefits of promotion to the petitioners of the state case. The decision dated 26/8/2021 was a result of such direction issued by this court, and it was specifically decided that so far as promotion to so far as those teachers who are governed by the decision dated 14/12/2015 and 18/7/2019, they will be entitled to get seniority as well as pay scale from the date of their appointment in grade 1. And so far as grade 2 is concerned, upon completion of 12 years from the date of their appointment, they will be promoted to grade 2. It was also decided that all the financial benefits arising out of retrospective promotions will be granted to them, inasmuch as such promotion was essentially in the nature of time-bound promotion, and reservation roster etc. was not to be followed in promotion to grade 1 to grade 2. But so far as grade 3, 4 and 7 are concerned, the same was subject to preparation of gradation list. The reservation roster was to be followed, and it was to be filled subject to availability of vacancy. It was observed that with regard to preparation of seniority list, the different litigations were pending before the High Court, and on account of such situation, the grant of promotion was hindered, and in number of cases, the litigants were granted promotion with retrospective date. A specific reference was made to the case of Dinesh Chandra Mehto, which was affirmed in LPA number 211 of 2019 and SLP number 10742 of 2021, and a decision was taken to give notional promotion to grade 3, grade 4 and grade 7. As per amended seniority list, amended gradation list subject to availability of post. And it was also decided that the promotion which was granted earlier will not be nullified, and the retrospective promotion will be granted notionally with effect from availability of vacancy. It was also decided that in case of persons not joining the promoted post, the notional promotion will not be granted. From the perusal of the decision dated 26/8/2021, it is also clear that the notional promotion was granted so that to grade 3, 4 and 7, so that the further promotion also could be granted to higher grades, taking into consideration the date of notional promotion. This court is of the considered view that rule इसको quote करिए, rule 58 and 50 and 74 of the financial rules, 58 of the Jharkhand Service Code and 74 of the financial rules are quoted as under. This court is of the considered view that the aforesaid rule is amply clear that the question of that a government servant shall begin to draw the pays and allowance attached to his tenure of a post with effect from the date on which he assumes duties of that post. Rule 74 also clearly provides that all authorities which are competent to sanction revision of pay or grant concession to the government servant should bear in mind that retrospective effect should not be given to financial sanctions except in exceptional circumstances without the special approval of the government. This court finds that the judgments which have been relied upon by the petitioner in order to have monetary notional benefit, in the monetary benefit of notional promotion, are the judgments in which the juniors to the incumbent were granted promotion. However, under normal circumstances and under such circumstances, this court has repeatedly held that Rule 58 of the Jharkhand Service Code and Rule 74 of the financial rules will not come in the way to grant monetary benefit to those whose juniors have been granted such benefit. The promotions involved in the present case are not mere financial upgradations, but they are substantive promotion subject to satisfaction of the conditions prescribed in the rules against vacancies where roster clearance is also required to be considered. The present petitioners have not moved this court earlier claiming any promotion, nor it is their grievance that any junior to them have been granted such promotion. There is no such grievance. 3 बार आपसे पूछा था.
नहीं, वो नहीं है. In failure in compliance of rule itself, there is laches on the part
That's
of the government
That's
who has not, the authority concerned of the Latehar, who has not considered, and ultimately it has been considered from the date. My promotion is never in dispute. It is all together in time. Rule को जो देखा जाए कि rule बोलता है कि 8 years. It is failure on
This
the
court
part
is
of
of the considered view that merely upon completion of the merely upon entitlement of being considered for promotion upon expiry of the period prescribed in the rules, the petitioner cannot claim automatic promotion unless there is a conscious exercise on the part of the respondents to grant such promotion. And so far as payment of financial benefits out of promotion is concerned, in terms of Rule 58, the financial benefit commences on the date the incumbent joins the promoted post, and not any date anterior to that. This court is of the considered view that the notional promotion was granted to the petitioners on account of the reasons cited in the aforesaid decision, and certainly the petitioners would be entitled for its benefit while considering further promotion, but so far as monetary benefit is concerned, no such case has been made out by the petitioner for grant of notional promotion, for grant of monetary benefit right from the date they have been notionally promoted, or they became entitled for promotion in terms of the rules. If such an order is passed, the same would be contrary to the judgment passed in the case of Dinesh Chandra Mehto, where he was granted promotion not from the date he became entitled to be promoted, rather he was granted promotion from the date his juniors were granted the promotion. And the monetary benefit was also accordingly granted. Since no case has been made out by the petitioner regarding discrimination against any junior, nor it is his case that any of his juniors has been granted any benefit which has been otherwise denied to the petitioner, this court is of the view that the claim for monetary benefit on account of notional promotion which has been granted to the petitioner cannot be granted on the face of the provisions of Rule 58 of Jharkhand Service Code and 74 of the Financial Rules. On account of the aforesaid facts and circumstances, this court finds no merit in this writ petition, which are accordingly dismissed. There will be lot of corrections, you will not get the same thing, but this is what the ratio is, whatever I have to say.
Not one thing, not only will not the Rule 58 and Rule 74 applicability when
आप
if
हमको खाली इतना बता दीजिए, जिन लोगों को उनके जूनियर को प्रमोशन के डेट से मिला है,
हम जो वो सिमिलरिटी फैक्ट्स पर नहीं जा रहे हैं, रेशियो केवल ये है जो कि if there is no latches on the part of the applicant. Had it been a कि अगर हमको उस डेट पर अगर हमको प्रमोशन मिल जाता हो तो हमको उसका बेनिफिट भी मिल जाता, लेकिन ये प्रमोशन उस दिन नहीं देते हैं, वो सेवरल लिटिगेशन के कारण प्रमोशन को पेंडिंग रखते हैं, जबकि रूल प्रेस्क्राइब करता है कि एवरी ईयर प्रमोशन जो है देना है। वो रूल को भी फॉलो नहीं करते हैं। 2003 में अगर रूल को फॉलो करते तो उस दिन हमको प्रमोशन मिल जाता मॉनेटरी बेनिफिट के साथ, बट इट हैज बीन कंसीडर्ड एंड ग्रांटेड 2019। तो उस इशू पर 73 और
58 or
Mine.
74.
Mine.
This is what my view is.
Mine.
You challenge it
Mine.
before the division
Mine.
bench, right?
माय लॉर्ड का जो भी वर्डिक्ट आएगा वो हमेशा एक्सेप्टेबल है।
ऐसा नहीं
हियर
है।
बिफोर द कोर्ट,
नहीं।
हियर बिफोर द
जो हमको समझ आया
Mine.
किए हैं। अब जो डीबी को समझ आएगा डीबी
Right.
करेगा, जो सुप्रीम कोर्ट को समझ आएगा वो
Mine.
सुप्रीम कोर्ट करेगा।
अभी तो माय लॉर्ड का जो जजमेंट है वही हमको एक्सेप्टेबल है।
Item 3, WPS 633 of 2023.
Today I have received the counter, tomorrow I will file the counter. This week, next week, any day as per legislation.
When do you want? When do you? The learned counsel for the parties are present. You are for the petitioner.
No, respondent management CC.
You have filed your count. You have filed your rejoinder.
I'll find it.
No counter has been filed.
Tomorrow I will serve him the copy. Tomorrow it will be filed. Today I have received everything and it will be reviewed. Tomorrow I will be
Learned counsel for the respondents submit that the counter affidavit in this case will be filed by tomorrow.
filed.
By tomorrow. Post this case on next Tuesday. आपको rejoinder file करना?
I have to bring on record the copy of NCWA rules edition. The last one I have.
That will be by counter also. Generally, what we code we at least that.
Rejoinder, if any, by thirtieth of April. Post on 1st of May in the supplementary pass list.
Item 4, WPS 6205 of 2023.
Who's for the petitioner? Absent.
Asked me whether we have filed counter or not. We have filed the counter affidavit and we have admitted the things that the petitioner deserves, lots the benefits of services. Para 10, 11.
CMPF is also agreeable to this.
And we have not received the counter. CMPF notes for which we have issued a letter and we have personally requested also. They are saying that Lord, since the matter is sub judice in the High Court, so no documents can be provided, which we have stated in para 13
Where
of
is
the
CMPF? Are you supporting, opposing? What is your stand?
Actually, we have not.
As per your nomin, yes, you have not received the counter.
full letter.
How the name of the wife changed in the service records of CCL? Yes, CCL.
As per my instruction, it's a clerical error.
How? That was his nomination filed way back. When did he file his
79.
nomination? When did he file the nomination for payment of CMPF? At that point of time, the name of wife was wrongly mentioned and the actual name was, and the name of daughter has been mentioned.
Yes.
How is it possible?
In 87, the daughter, the same name of daughter.
Yes.
His age is
No, I
wrong.
just want to know from them. You say it is a clerical error.
Yes.
Who has given that declaration? You have given the declaration.
which problem arose? There,
How?
this instruction is.
Because you have paid the money, so you want to defend it. It appears to be so.
Then also I will take the further instruction and inquire with the officer that
You get the file.
yes, get the entire
You
report.
get the entire file and let's figure out
That would be better.
whether it's a clerical error or since you are defending it because you have already committed an error.
Yes. So it's better, my lords, record may be called for.
You produce, you satisfy yourself because
Yes, my lords.
in the nomination form, whatever has been filled,
Yes.
very difficult to change.
Yes.
Where is his other family declaration?
That all I have to bring, my lords. I received a
And
very-
you
very-
respond to his counter. You produce the records.
Yes, my lords. Because I have received a very short statement of fact according to that.
Naturally, they have committed a mistake, they will defend their mistake.
Yes, my lords.
Because all the retirement benefits have been paid to her.
Yes, all the time.
Or let her go and seek a declaration from court. That would be
Yes.
better. There is a serious dispute regarding this fact. Where is the petitioner? I think it's always better to have a succession certificate
Yes,
in
for these-
such kind of a
Any
discrepancy.
dispute, yes.
It is not clear how your records were changed or whatever.
Yes.
There could be an error, we
Yes.
do not say, but the nomination was filled long back.
Yes, lords. And with respect to any dispute in nomination, my lords, the only remedy is, my lords, the declaration. Even in universities, even supposedly husband died and the wife of name is not there, they have to ask that we come up with the nomination. Even all the officers knows that she's her wife, but the law is that.
Even in the scheme also 64(3) we have that if the claim has to be settled other than nominee, then succession certificate is
So
needed.
you just cite it tomorrow. I'm posting it tomorrow. I want the council to be present.
Yes.
In his absence, I don't want to pass him on. Right? WPS number 6205 of 23. Counsel for the petitioner is absent. The counsel for CMPF has submitted that the CMPF has to act as per the nomination. The counsel for the CCL
Yes.
CCL has submitted that there were certain typographical errors,
Clerical mistake.
but it is not in dispute that in the nomination, the name of the petitioner was not appeared.
Yes.
Counsel for CMPF submits that in case of any error in nomination,
If in case of settling the claim other than
for the
from person,
in case of prayer to settle the claim in favor of a person other than the nominee, a declaration is required, succession certificate is required.
as per 64(3).
In case there is any error on part of CCL, then also a succession would be required. However, in order to grant an opportunity to the petitioner, post this case tomorrow. You know the counsel?
Lords, in morning he has come, my lords,
You
he
know
met
him
me.
otherwise?
Otherwise,
Otherwise, I
him?
know Prashant Vidyarthi, Mr. Prashant Vidyarthi.
Okay,
But
you
I'm
inform
listening
him,
to the same-
he can see the YouTube. Maybe
he
that
sits in
disorder
the
will
same hall
not.
where I sit.
He can see the YouTube. This is my observation. It may not be uploaded today itself.
Yes.
Okay.
Item 5. WPS 6653 of 2023.
Where is the petitioner? Yes. Supplementary counter affidavit has not been filed.
No, our counter affidavit isn't filed.
There was an order to file supplementary counter. That has
There
been
was an
filed.
order, but they have not filed. So If advised, if so advised, it was directed, they can file a supplementary counter affidavit.
If so advised, not required?
No, not at
All right. Argue your case.
Yes, ma'am. Last date I had given the some judgments and list of dates. In my leadership,
List of dates was not there.
then I'm giving as well.
Just a minute. Yes.
27/6/2008, the husband of the petitioner was appointed on the post of constable. On 27/6/2010, that is 2 years probationary period is there, as per police manual, and his services were confirmed under Rule 668 of the Jharkhand Police Manual. On 7/6/20, that is 12 years after his appointment, my lord, while he was performing his duty and vehicle were being checked, my lord, the husband of the petitioner stopped a vehicle for checking, and that vehicle, instead of stopping, crushed him, and he died on the spot itself while in the course of duty itself. Now thereafter, the respondents called the petitioner for settling the claims, that is several claims like family pension, compassionate appointment, etc. By annexure 4, a no due certificate was also issued to the petitioner that no outstanding dues is payable to the department by the husband of the petitioner. Now thereafter, the petitioner duly complied all the directions as and when she was directed to appear. She appeared, she submitted all the documents, that is affidavit and all declaration, etc. And on 25/3/21, a recommendation for grant of appointment on compassionate appointment of the petitioner was forwarded to the Commandant IRB to Chaivasa by the DIG. In the meantime, my lord, on 16/4/21, an inquiry cum recommendation letter hearing so and so, it was held that the husband of the petitioner died in harness due to an accident in the line of his duty. Therefore, the dependents of the deceased employee is entitled for ex gratia lump sum compensation, that is amounting to rupees 10 lakhs as per the circular which I have annexed in Annexure 2 of my writ petition. In December 20, pension was also started, my lord, 15,500 per month for the petitioner. And while she was getting the pension in 2021, a letter was issued that has been impugned herein. And in that letter, ex parte decision has been taken that since the husband of the petitioner, by taking advantage of a different caste certificate, he gained employment, therefore an order was passed that the family pension should be installed immediately, and subsequently by September 2023, this pension has been stopped and every benefits have been denied to the petitioner. So this is the case, my lord. Now earlier, 3 judgments I had given, my lord. Now on this point, recently while searching several judgments, my lord, I got hold of one Patna High Court judgment on exactly similar point. And this is a highly acclaimed judgment. My lord, may kindly peruse this judgment. Now in this case also, with my leadership, for fact, I want to show para 7. In this case, what happened, the husband of the petitioner, he was having some outstanding dues and some misconduct was alleged against him, and he died during the inquiry, my lord, and thereafter it was found in inquiry that the husband of the petitioner gained the employment on the basis of different caste certificate, as same as this case, my lord. Now in this case, what the Honorable Patna High Court held, this is at, for facts, may I read para 7, my lord. Para 7. Learned Counsel for the State, by referring to the materials brought in report, vehemently submits that after the death of the petitioner husband, she was advised to submit the required pension papers, and she was also given reminder for the same. In the meantime, the police inspector Manihari was also directed to inquire the matter of death as well as family details of the associate employee. The sub-inspector and the circle officer Shivaji Nagar Circle was also requested to inquire regarding the death and caste of the erstwhile employee. During the inquiry, it was found that the petitioner husband, namely Ram Vilas Ram, known as Ram Vilas Singh in his village, he was Kurmi by caste, but he obtained his caste certificate of Ravidas Harijan scheduled caste, and on the basis thereof, the petitioner husband obtained the appointment. In the aforesaid circumstances, it is submitted that as the husband of petitioner obtained the appointment on the basis of false certificate, the pension and other benefit have not been decided till date, and guideline has been sought for the police headquarters. In response to the abandonment submission made on behalf of the responsive Mr. Jagdish Prasad Singh, the petitioner submits that the petitioner's husband was appointed way back in the year 1976. And to be more specific, 14/9/1976, and after having verified all these certificate testimonial, his joining was accepted. And during his lifetime, he was also allowed promotions twice, and before he found placeless in the year 1985, at no point of time any so-called notice has been served on the erstwhile employee, nor any inquiry has been conducted in this regard. So what has been held in the last para, my lord? If my ladyship comes to para 16, second last page. It is a settled preposition of law that judicial inquiry or departmental proceeding against a delinquent totally abates on the death of an employee, for the simple reason that in order to punish an employer, there must be a subsistence of employer and employee relationship. Once an employee dies, the said relationship ceases. The defense, if any, is a personal defense available to the employee, and no person can be substituted in place of a dead employee and defend the conduct of a dead employee. And as such, no order have been passed withholding the retirement or any outstanding dues. In view of direction so and so, the repetition was allowed and she was directed to pay all the retired benefits.
This judgment has attained finality.
Yes, this is as per I have verified everywhere, my lord. State of Bihar has not appealed against this order. It has attained finality. And this is a highly acclaimed judgment. It has been reported in Live and every other platforms, my lord. This judgment. Now another one Supreme Court judgment I want to be live. This is 1998 volume 8 SEC. In the top I have mentioned page number 194. Vasudev Tiwari versus Sidhu Kanu University and others. If my ladyship comes to page 3, I have highlighted the portion. Whether the applicant has been given an opportunity of being heard before terminating his service, and in the absence of same, whether such termination is valid. So in this case, I want to show in this particular circumstances, he was not so caused, nor any proceeding was pending against him. Now, second page, my lord, the condition precedent for exercise of this power is that an appointment has been made contrary to Act, rules, statute, and regulation or otherwise, in order to arrive at a conclusion that an appointment is contrary to the provisions of Act, statute, rules, or regulation, etc., a finding has to be recorded. And unless such a finding is recorded, the termination cannot be made, but to arrive at such a conclusion, and unnecessarily an inquiry will have to be made as to whether such appointment was contrary to the provisions of the Act, etc. If in a given case such exercise is absent, the condition precedent stands unfulfilled. To arrive at such a finding, necessarily inquiry will have to be held, and in holding such an inquiry, will the person whose appointment is under inquiry will have to be issued to him. If notice is not given to him, then it is like playing Hamlet without the Prince of Denmark. That is, if the employee concerned, whose rights are affected, is not given notice of such a proceeding and a conclusion is drawn in his absence, such a conclusion would not be just, fair, or reasonable as noticed by this court in DTC Mazdoor Sabha case. In such an event, we have to hold that in the provision there is an implied requirement of hearing for the purpose of arriving at a conclusion that an appointment has been made contrary to the Act, statute, rule, or regulation, etc. And it is only on such a conclusion being drawn the services of the person could be terminated without further notice. This is how section 35(3) in this case will have to be read. Admittedly, in this case, notice has not been given to the appellant before
What is
holding
the effect of fraud?
Yes.
What is the effect of fraud?
Effect of fraud is it is continuing wrong, and it
What
can.
is the effect of fraud? Our privilege jurisprudence democracy. What is the effect of fraud?
Effect of fraud is that it can be cured anytime.
It's a nullity.
It's a nullity from the basic inception, I may assume. But in this case, there are several things, my ladyship, which I want to rely upon. First, the pension rules also stipulate.
एक चीज ये बताइए आप. You gave him appointment by virtue of a caste certificate. Is there any caste scrutiny committee report? Do you have the jurisdiction?
There is no caste scrutiny committee report, but there is an administrative inquiry.
It has got no value. You have no business to cancel the caste certificate granted to one or the other person.
In prima facie, it appears that
Prima facie, on the basis of prima facie opinion, you cannot stop the pension.
the on the fact that his father belongs to a backward class and he producing ST caste.
So basically you are disputing the caste certificate produced by him during the employment.
Yes.
You don't have any business to interfere with that. Only the caste scrutiny committee has got the jurisdiction, none else. पड़ोसी बोल दिया कि ये कास्ट नहीं है तो चलेगा क्या?
एडमिनिस्ट्रेटिव इंक्वायरी हुआ,
इसका कोई रेलेवेंस ही
अंचल
नहीं,
अधिकारी का है वहाँ।
कोई इसका रेलेवेंस ही नहीं।
No, it is a fact that his
Fact
father
means
belongs.
what?
His father belongs.
Who
to
will say it's a fact? आपको मालूम है? Personal knowledge है।
No, inquiry it has.
What inquiry?
No, may I-
Ex parte inquiry. You conduct you tell us after the judgment of Kumari Madhuri Patil, can anybody touch the caste certificate?
Scrutiny committees.
That's it. So इस पर तो हम कर सकते हैं, ये नहीं बोल सकते हैं कि इंक्वायरी नहीं हो सकती।
माधुरी पाटिल केस में भी बोला गया है कि इट्स हैड टू बी कंडक्टेड विद इन अ रीजनेबल टाइम, एंड रीजनेबल टाइम हैज बीन
We
डिफाइंड
do
इन
not
दैट.
know reasonable time. आप वहाँ oppose करिए. We do not know.
हाँ, that also I am placing a note.
That much should be sufficient.
Yes, that is also sufficient.
That is also sufficient.
Yes.
इससे ज़्यादा कुछ बोलने का जरूरत ही नहीं है. You cannot question his caste certificate under any circumstances. बाकी आपको जो करना आप कर सकते. That is the only reason.
Yes. Some judgment I got through.
Yes.
In 2004. Para 9. Regarding pension, it says that it is a statutory provision and a statutory benefit, the nature of public employment which rights derive from that statutory provision. Now, paragraph 19.
Para number
19.
19.
Very good. It was then contended by the Sri so-and-so since the appellant has rendered about 27 years of service, the order of dismissal be substituted by an order of compulsory retirement or removal from service to protect the pensionary benefit of the appellant. We do not find any substance in this submission as well. The right to salary, pension and other service benefit are entirely statutory in nature in public service. The appellant obtained appointment against a post made for the reserved category by producing a false caste certificate and by paying a fraud. His appointment to the post was void and null is, in the eye of law, the right to salary or pension after retirement flow from the valid and legal appointment. The consequential right of pension and monetary benefit can be given only if the appointment was valid and legal. Such benefit cannot be given in the case where the appointment was found to have been obtained fraudulently and rested on false caste certificate. So another judgment.
Here also the caste certificate was found to be false after due inquiry from caste scrutiny committee certificate.
But administrative.
No, in this particular case, in the case before the Honorable Supreme Court, the scrutiny committee had given the report. Yes.
Investigation and inquiry.
It was done by caste scrutiny committee pursuant to the judgment of Kumari Madhuri Patil. Government of Kerala constituted a scrutiny committee by notification. Then the inquiry into the caste status was referred to the scrutiny committee. Thereafter, this order has been passed. You can't do it. The law is well settled. Caste certificate, once granted, you can't touch it. Even High Court cannot decide this issue under 226. All the matters regarding caste dispute, particularly SC/ST, has to go through the committee report. There are so many criteria to determine. वो पड़ोसी बोल दिया उससे शादी हो गया ऐसा नहीं होता, right? It is a very technical issue. Lot of inquiry involved.
This fact comes from the inquiry that his father belongs to backward caste and he renders service on backward caste, and he using ST caste.
We do not know what he is using, what they are using. He had a caste certificate of SC,
ST.
ST,
And
ST.
ST, yes.
Yes.
And he belongs to his. It has come that he belongs to backward. BC.
अपने ही हाई कोर्ट का जजमेंट है ऑनरेबल जस्टिस चंद्रशेखर प्रसाद कि रिटायरमेंट के बाद भी इस तरह की स्क्रूटनी हो सकती है बिकॉज सर्विस बेनिफिट्स आर स्टिल फ्लोइंग आउट ऑफ दैट योर पेंशन इज फ्लोइंग आउट ऑफ दैट सर्विस बेनिफिट इफ योर husband or whosoever has committed fraud then no benefit can flow out of it. Of course recovery नहीं हो सकता.
यहाँ पुलिस में क्या होता है, मैं जैसे बताते हैं अपॉइंटमेंट के टाइप का स्क्रूटनी होता है, उसके बाद एक वेरिफिकेशन रोल भी होता है पुलिस जवान के केस में. 2-3 राउंड इनका टेस्टिंग होता है, उसके बाद ये लोग करते हैं उस पर.
Where is the impugned order? Kindly read the impugned order.
यस. उपयुक्त विषय के संबंध में सादर सूचित करना है कि इस वाहिनी के स्वर्गीय आरक्षी 422 विजय सिंह बांदा की नियुक्ति दिनांक 27/6/2008 पूर्वाह्न में आरक्षी के पद पर हुई थी. ये कोविड-19 ड्यूटी हेतु रांची जिला अंतर्गत चानो थाना में प्रतिनियुक्त थे. कर्तव्य के दौरान दिनांक 7/6/20 को सड़क दुर्घटना में इनकी मृत्यु हो गई थी. इनके सेवा पुस्त में उत्तराधिकारी के रूप में अंकित इनकी पत्नी श्रीमती लालमती देवी का एप्लीकेशन नंबर सो एंड सो के द्वारा इनका पेंशन राशि 15,500 रुपया स्वीकृत किया गया है. इन्हें भुगतान की राशि 72,700 रुपये का भुगतान किया जा चुका है. उक्त स्वर्गीय आरक्षी की आश्रित पत्नी लालमती देवी को अनुकंपा के आधार पर नियुक्ति हेतु प्रस्तावित कार्यालय के ज्ञापन द्वारा पास भेजा गया है. उल्लेखनीय है कि अपर पुलिस महानिदेशक झारखंड सशस्त्र पुलिस रांची के ज्ञापन सो एंड सो एवं पुलिस उप महानिरीक्षक कार्मिक झारखंड रांची का ज्ञापन सो एंड सो के द्वारा इस कार्यालय को सूचित किया गया है कि स्वर्गीय आरक्षी 422 विजय सिंह बांदा फर्जी अनुसूचित जनजाति प्रमाण पत्र के आधार पर नियुक्त हुए हैं. ये वास्तव में हो जनजाति अनुसूचित जनजाति के नहीं बल्कि गोप जाति पिछड़ी जाति के सदस्य हैं. इस संबंध में अंचल अधिकारी कोटिपानी का चाईबासा के द्वारा समर्पित जांच प्रतिवेदन के आधार में जिला दंडाधिकारी सर उपायुक्त चाईबासा द्वारा इनके कार्यालय का पत्रांक सो एंड सो द्वारा सूचित किया गया है. सुविधा के लिए उक्त पत्रों की छायाप्रति अवलोक संलग्न है. अतः अनुरोध है कि स्वर्गीय आरक्षी 15 की आश्रित पत्नी लालमती देवी का पेंशन का भुगतान बंद करने की कृपा की जाए.
सिर्फ इसी पॉइंट पे डिसाइड कर देते हैं कास्ट स्क्रूटनी कमेटी. You want this also? तो हमको फिर बहुत कुछ बोलना पड़ेगा. I will not agree to that judgment. I have got right not to agree.
Yes.
What is your choice? You tell us. If you want only on caste scrutiny committee, I'll pass the order.
One Jayanti Devi also this honorable court had placed, my lord. That also says that no action can be taken against the deceased employee.
No action can be taken. He cannot be dismissed. But if his employment is obtained by fraud,
Then who is going
then
to?
all the service benefits has to go.
How can it be proved that it has been obtained in fraud? Ex parte.
Through caste scrutiny. कास्ट स्टेटस तो आदमी का रह ही जाता है ना.
कमेटी के पास भी तो एपीआर होने का राइट है ना. वो कौन अब एपीआर होगा? That is the question.
You see, you are the person who will represent him because you are the family member. You are claiming.
Law says that delinquent cannot be substituted.
The case of defalcation and embezzlement, the department proceeding is started.
It started. It is not started
This
yet.
is started. The delinquent implies necessary to appear.
What do you want? If you want a
It is not a
full-fledged
case of-
decision, I'll give you a decision. Then I'll have to reserve it. अगर अभी चाहिए order तो caste scrutiny committee पे हम खत्म कर सकते हैं. बोलिए दोनों चाहिए. What is your choice?
Then again they will refer to caste scrutiny committee and
They
say,
will. They will. They might not, we do not know. दोनों पॉइंट डिसाइड करते कोई बात नहीं। हमको जजमेंट खोजना पड़ेगा ऑनरेबल जस्टिस चंद्रशेखर साहब, मिल जाएगा।
reserve the leadership also. Because I want a detailed order on this point because
No problem. लिखिए। For the learned counsel for the parties, this writ petition has been filed for the following relief.
and one thing, ex gratia lump sum compensation she is entitled today also, ma'am. Because he died in the course of duty, and that is admissible. That is admissible from the impugned order also. And the resolution I have annexed is in Nature 2, so therefore she is entitled for the 10 lakhs ex gratia lump sum compensation, which they are not paid till then. Because it is a settled, admitted fact that he died in the course of duty while checking the vehicles. He was crushed by the 407 vehicle.
And this writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the husband of the petitioner was appointed on the post of police constable at IRB 2 Chaibasa on 27/6/2008, and after due inquiry and verification, and his services were also confirmed on 27/6/2010 in terms of Rule 668 within bracket A of Jharkhand Police Manual. He submits that while on duty, he expired on 7/6/2020 when he was crushed by a vehicle. And as per the policy of the state, a police personnel dying on duty is entitled for ex gratia payment of rupees 10 lakhs, which has not been paid to the petitioner till date, and the other service benefits flowing out of his service is to be paid to the petitioner,
Including compassionate amount.
including compassionate amount. The learned counsel submits that the petitioner was paid pension and a further amount of rupees 7,27,745 by way of gratuity. But the respondents suddenly issued the impugned letter dated 21/5/2021 stating that the husband of the petitioner belongs to the community Gok, which is a backward class community, and he obtained employment on the basis of a caste certificate stating that he belonged to a community of scheduled tribe, namely Gok. And on that basis, the pension was stopped, and consequently, ex gratia payment has not been paid, nor compassionate appointment has been paid.
Though recommended.
He submits that appropriate recommendation was made for the purposes of grant of compassionate appointment and there is no other legal impediment in grant of compassionate appointment. The Learned Counsel has submitted that the impugned order has been passed at the back of the petitioner and after the death of the ex-employee. No proceeding was ever initiated with any such allegation against the ex-employee. And now, in absence of the ex-employee, no such step could have been taken. He has also submitted that the inquiry was committed, the inquiry was conducted by certain officers of the respondents as mentioned in the impugned order. The inquiry report has also not been placed on record. The Learned Counsel has relied upon the judgments passed by the Honorable Supreme Court in the case of यही सारे judgments हैं
हाँ
सारे जो उस दिन लिखे थे
हाँ वो तीनों और आज जो दो दिए हैं
हाँ।
ऑनरेबल पटना हाई कोर्ट और ये
in the judgment passed by the Honorable Supreme Court in the case of Kumari Madhuri Patil and another versus Additional Commissioner Tribal Development and others reported in bracket 1994 bracket close 6 SCC 241 to submit that the caste scrutiny committee constituted pursuant to the state judgment has the exclusive jurisdiction to give any declaration in connection with caste of one or the other person, particularly when the person belongs to scheduled caste or scheduled tribe. Once the caste certificate has been issued, no other authority has any business to declare the same illegal and deny any benefit to the petitioner. He submits that the entire exercise has been done only to deprive the petitioner of monetary compensation and compassionate appointment. The Learned Counsel has further relied upon in the judgment passed by Honorable Patna High Court in CWJC number 9735 of 2021 decided on 11/1/2023 to submit that in the said case the similar allegation was made against the ex-employee and it was alleged that he actually belonged to a community called Kurmi but had obtained the employment on the caste certificate under Ravidas belonging to scheduled caste. And on that ground, the writ petitioner was deprived of the pensionary benefits. He submits that the provisions of Bihar Pension Rules 1950 was taken into consideration and it was held that no departmental inquiry could be initiated and after the death of a person, there was no scope for conducting any inquiry in connection with legality or validity of his employment. And consequently, the action of the respondents was and consequently, it was held that the impugned action of the respondents in not making retirement, outstanding dues and family pension was wholly unjustified and not sustainable. An appropriate direction was also issued. He has referred to paragraphs 15 and 16 of the state judgment which are quoted as under. The Learned Counsel submits that the present case is on identical circumstances. He has also relied upon a judgment passed by Honorable Supreme Court reported in bracket 1998 8 SCC 194 within bracket Vasudev Tiwari versus Sidhu Kanun University and others and has submitted that in case a person has expired, the question posed for consideration was whether इसमें तो ऐसा कुछ नहीं है.
डेथ ये इंक्वायरी का पेंडेंसी में हुआ था इसमें था कि whether without holding any
Okay.
inquiry
And submits that in the said case some disciplinary proceeding was initiated and the employee had expired
in the
pending inquiry. He submits that under such circumstances, the Honorable Supreme Court was of the view that the inquiry could not be continued, and as the person concerned would not have an opportunity to participate in the inquiry proceedings.
and also the delinquent cannot be substituted.
And the delinquent cannot be substituted and no proceeding could be continued against the legal heirs. The learned counsel appearing on behalf of the respondents, on the other hand, has opposed the prayer and has submitted that
Paragraph 13 and 14 of my court.
and has referred to paragraph 13 and 14 of the counter affidavit. Stating that the respondent got information from the Additional Director Police, Jharkhand Armed Force, Ranchi, dated 13/5/2021, and another letter dated 4/5/2021 issued by DIG Police Personnel, Jharkhand, Ranchi, wherein it was mentioned that the husband of the petitioner was appointed on the basis of a forged scheduled tribe certificate. A reference was also made to a communication contained in memo dated 15/12/2020, wherein the district magistrate cum deputy commissioner West Singhbum had also confirmed the aforesaid aspect, and on the ground the verification was duly made that the husband of the petitioner did not belong to scheduled tribe category, or rather he belonged to another caste, namely Go, which does not belong to scheduled tribe.
Inquiry report is page 36.
He
and
submits that the inquiry report has been placed on record as contained in page 36 of the counter affidavit,
Page 41.
36 and 41, and submits that the circle officer has also certified that the husband of the petitioner did not belong to the community Ho and belonged to the community Go. The learned counsel has submitted that the employment has been obtained fraudulently by giving a false declaration regarding caste, and therefore the impugned action does not call for any interference. He submits that employment obtained through fraud is a nullity in the eyes of law. He has relied upon judgment passed by Honorable Supreme Court reported in bracket 2004 bracket close to SCC 105, and has referred to paragraph, what's the paragraph?
19.
Paragraph 19 of the said judgment, which is quoted as under. However, from the perusal of the said judgment, it is clear that the matter regarding caste was considered by the caste scrutiny committee. Right? है ना? Correct?
Yes.
And thereafter the order was passed by the authorities. In the present case, admittedly, the matter has never been referred to caste scrutiny committee, and it is only the officers of the respondents who have conducted certain inquiry and have issued the impugned order stopping the pension of the petitioner. That's right. Argument concluded. तो जजमेंट कर दीजिए. काम तो आप हमारा बढ़ा दिया, आप लोग असिस्टेंस नहीं देते, इनको भी कुछ पता नहीं है. आप भी कुछ नहीं लाए fraudulent appointment पर?
I think, my lord, there are two issues. So far, stoppage of pension is concerned, my lord. There is a statutory provision for stoppage of pension. There are two recourses, 43 and 130. But having said so and having the statutory provision as such, if there is a fraudulent and forged document and appointment has been obtained, then those law will not apply. But one fact will be remain that whether there is a competent authority or due inquiry has been done by that or not. Unless that finding is there, my lord, my office cannot stop it, or in view of that impugned order, we have only said that you intimate me after due inquiry. That's all. That is
You
my
have not
instruction.
stopped the pension?
No. Till that I don't stop because I have asked them.
No, as per my instruction, the pension has been stopped.
हाँ, क्योंकि हमने इंक्वायरी के लिए बोला उनको, वो इंक्वायरी जब तक नहीं देंगे तब तक तो रुका रहेगा इनका पेंशन. हमने ऑथराइज कर दिए थे. पेंशन, ग्रेच्युटी एंड कम्यूटेड तीनों हो चुका है.
पेमेंट हो चुका है?
नहीं, पेमेंट तो स्टेट करता है. हम तो
आपने पेमेंट तो कर दिया है ना?
पेंशन तो इनको मिल रहा था, ग्रेजुएटी मिल चुका है. पेंशन.
The learned counsel appearing on behalf of Accountant General.
ये हमारा इंप्यून ऑर्डर में लिखा हुआ है, पीपीओ नंबर वगैरह सब लिखा हुआ है.
The learned counsel appearing on behalf of the Accountant General has submitted that the provisions of Rule 43B and 139, which deals with stoppage of pension, will not apply in a case of appointment obtained by fraud, but in absence of any inquiry by the competent authority, the respondent's state was not justified in.
ये वाला आर्गुमेंट हमारा इंस्ट्रक्शन यही है कि हमने बोला कि आप भी इंक्वायरी करके खबर कीजिए, इंटीमेट.
Okay. He has submitted that the Office of Accountant General has instructed the state, requested the state to conduct necessary inquiry and then intimate the Office of Accountant General.
Yes.
That's all.
क्योंकि ये इस तरह का अपॉइंटमेंट जो होता है जो एक्चुअल बेनिफिशियरी है उनका प्रॉब्लम हो रहा है, उनको नहीं अपॉइंटमेंट मिला. So therefore I think, my lord, if the scrutiny committee will get the matter in, then it will be, otherwise it is depriving some.
आप लोग जजमेंट तो नहीं लाए ना? ये तो हम अभी डिसाइड करें.
हम इस इशू पर बोल, हम तो केवल असिस्ट कर रहे हैं.
फ्रॉडुलेंट अपॉइंटमेंट पे जजमेंट नहीं लाए कि मरने के बाद क्या होगा? नहीं लाए तो हम खोजेंगे.
इंस्ट्रक्शन नहीं है वो, इसीलिए हम तो केवल असिस्ट कर रहे हैं.
रिस्पोंडेंट की बात कर रहे, स्टेट की बात. उनको तो लाना चाहिए.
I think, my lord, that judgment which my lord.
नहीं तो आप पटना हाई कोर्ट का जजमेंट साइड कर रहे हैं कि हो ही नहीं सकता है, तो हम लोग को देखना पड़ेगा ना. ऐसा हाई कोर्ट का जजमेंट है, हम लोग ऐसे इग्नोर भी नहीं कर सकते हैं. We cannot ignore a judgment of a high court. Then सिंगल जज चाहे डीपीएस से कोई मतलब नहीं है. जजमेंट इज अ जजमेंट.
सुप्रीम कोर्ट भी बोला कि अगर डेथ हो गया तो इसके बाद तो हम उसको रिमांड बैक भी नहीं कर सकते हैं, क्योंकि एम्प्लॉय पार्टिसिपेट नहीं कर पाएगा.
डिफरेंस ये है जजमेंट में कि in those judgment the department proceeding initiated on the basis of false embezzlement, charge of embezzlement or fraudulent. In that case, Supreme Court says that if he died, he could not produce before the inquiry officer, so department proceeding cannot be initiated. But in this case, I have initiated a false certificate in issue that has been submitted. That can be verified from his ancestor or other family member.
The learned counsel appearing on behalf of the state has also submitted that the judgment of the Honorable Supreme Court does not apply to the facts of the case, as the caste status of a person can still be verified even after his death. Right? Post this case for judgment on 8/7, 8 July.
Item 28, WPS 2113 of 2023.
Before I must start, I must point out that one IM was filed by us 6428, upon which orders have been passed. Order number 5. The respondents had been directed to file a reply to that. Then order number 7 also mentions that. They have filed a reply also, but according to me, the issues which we raised in a specific in that IA has not been responded.
They will respond to it only when IA is allowed.
Yes,
This IA is
I'm
pending.
just pointing out, Lordships asked them, IA 26/7/23. In the meantime, as platform put up this case after 2 weeks, in the meantime, the respondents are directed to file reply to the interlocutory application signed by the petitioner. They were directed to file reply to the interlocutory application. And then order number 7 says that IA shall be considered at the time of final.
That's right, whatever they have
Fine.
filed there.
Yes, I was just in nutshell, I'll take your lordships to all the documents. In nutshell, the case of the petitioners are twofold. There had been 2 advertisements issued by the respondents.
You have filed your necessary affidavits. There is nothing which is uncontroverted or whatever. After बीच में मत बोलिएगा. आपका उसके बाद कॉस्ट भी लगा था वो सब जमा कर दिए.
Yes.
Yes, please.
Right. Plus 2 advertisements had been issued. I'll give a brief of the whole case. 2 advertisements had been issued by the respondents. Advertisement number 2 of 2023 and for backlog vacancies 3 of 2023. What has happened this is the appointment of PG teachers, स्नातकोत्तर प्रशिक्षित शिक्षक प्रतियोगिता परीक्षा, and advertisement number 2 is also for the same purpose. One is niyamit bharti, regular appointment, another is backlog. If lordship kindly come to page number 65 for a moment, just to give what exactly the case of the petitioners is here. Advertisement starts from page number 63, page 63. It is regular vacancy. Kindly come to page 65. It is subject-wise vacancies advertised. kindly come to plus seal number 1 itself. स्नातकोत्तर प्रशिक्षित शिक्षक जीव विज्ञान. What's you got? Kindly have total number of posts are 218 and the reservation for unreserved category is supposed to be 40%. I'll take your lordships to the chart which we have prepared. It is supposed to be 40%, so it has to be 87, but they have notified 94 posts, so excess than 40% here. Then
Excess. So reserved category should be how much according to you?
unreserved categories has to be 40%,
Okay.
and EWS is 10%. So 10% has been carved out from the unreserved category itself. So there can't be a reservation more than 50%. So unreserved and EWS makes 50%. 40% will be the unreserved, अनारक्षित, and आ क व जो लिखे EWS ये 22K. If lordship kindly see 218 is the total number of vacancies notified for this subject and post. Here what happens? Instead of 87, they are notifying 94 for unreserved category.
92.
And
92.
94.
यहाँ पे 92 है अनारक्षित.
अनारक्षित 94 जीव विज्ञान में.
जीव विज्ञान ये 92 था अनारक्षित. 218 के नीचे 92.
नहीं, ये ऊपर वाला देखा जाए, ऊपर वाला देखा.
अच्छा,
ये ब्लॉक
वाला.
उस
Okay.
तरह से. जी.
Alright.
तो ये 94 है, 87 होना था, ये एक्सेस हुआ. अब EWS Act 2 पर वो होना चाहिए 10%. ये 22 किए. Now kindly come where problem comes up. पिछड़ा वर्ग kindly see serial number 6. It is as per the state notification supposed to be 6%, but here they say 0. So अत्यंत पिछड़ा वर्ग we are concerned with, तो इसको 0 कर दिया. Likewise, in each and every subject this has happened.
You see, अनुसूचित जाति.
अनुसूचित जाति is almost
1.
बराबर 1. ये कुल रिक्ति है 22. सॉरी 1 नहीं है, जस्ट
महिला. अच्छा
जी.
ओके, कुल रिक्ति है 22.
जी.
Then this 2 and which is 0?
0 is छठा नंबर में लिखा है. सॉरी, पिछड़ा वर्ग अनुसूचित 2.
हाँ, yes.
छठा नंबर में
हाँ.
पिछड़ा वर्ग अनुसूचित 2.
Yes.
इसका कुल रिक्ति है 2, उसमें 0 कर दिया.
0 महिला पर है.
2 सॉरी, हाँ ये 2 किया हुआ है. 2 सॉरी 2 किए. ये 6% अगर 218 कर लेंगे तो इट हैज टू बी 13. काइंडली कम टू पेज नंबर 5 of the supplementary affidavit which will give the chart of exact percentage and calculations. सबसे पहला ही आइए होगा 28/4/23 का. यस, यही बात. आइए नहीं सप्लीमेंट्री और सिर्फ गॉट इस तरह का चार्ट. हम बोले कंपाइलेशन एक बनाने से इतना बल्कि फाइनेंस सुविधा होती
ये कन्वीनियंस कंपाइलेशन के
होना
बिना
चाहिए.
ये सब कैसे रिजर्वेशन
होना
का
चाहिए,
कैसे डिसाइड?
होना चाहिए. लॉर्डशिप व्हाट्स क्लोज आई कैन डू दैट.
आप कर दीजिए भाई. कोई कन्वीनियंस
कर.
कंपाइलेशन के बिना, छोटा नोट के
नहीं,
बिना
नहीं, ठीक.
कैसे हो?
नहीं
Can't be decided like
आइए,
this.
आइए.
The selection process is over.
मतलब इन लोग क्या किए, जो कुछ वैकेंसी सबका छोड़ करके कुछ सब्जेक्ट्स का अपॉइंटमेंट किए हैं, बाकी नहीं हुआ है. लेकिन जो अपॉइंटमेंट भी किए हैं वो ईयरमार्क करके वैकेंसी जो क्लेम हमारा है वो लिख दिए हैं कि सब्जेक्ट टू रिजल्ट रहे। ये मेरी इंफॉर्मेशन है।
ऐसा है क्या? नहीं, ऐसा तो आपको सप्लीमेंट्री एफिडेविट में फाइल करना पड़ेगा ना, बिकॉज इफ the situation is very has a different connotation.
Yes.
If all the vacancies have been filled, तो सबको पार्टी बनाएंगे, क्योंकि दूसरे को हटा के ही आपको जगह मिल सकती है।
नहीं, ऐसा हम
और अगर नहीं फिल हुआ है तो एफिडेविट दीजिए।
नहीं देते, नहीं हुआ।
नहीं हुआ है, क्या स्टेटस है?
4 सब्जेक्ट का हुआ है, उसमें कुछ वैकेंसी।
आपका कौन सा सब्जेक्ट?
कई लड़के हैं, ढेर सारे।
ऐसा थोड़ी, इस तरह से सबका सब्जेक्ट मिक्स करके घालमेल हो जाता है।
हम एफिडेविट दे देते।
घालमेल हो जाता है।
घालमेल नहीं, इशू है।
नहीं, इशू है, ठीक है, लेकिन सब्जेक्ट वाइज भी तो है ना।
हाँ, नहीं, इनका खुद का एडवर्टीजमेंट ऐसा दिखा रहा। और एक बहुत अपरेंट चीज जो दिखाएंगे माय लॉर्ड्स, हुआ क्या, एक तो इशू ये हुआ, दूसरा इशू क्या है, काइंडली सी जस्ट मतलब ये कीजिए। आप
किस कैटेगरी में अप्लाई किए थे?
हम BC2 हैं।
BC2 ऑल ऑफ यू?
हाँ, सारे BC2 वाले। इसमें क्या हुआ कि
ऐसा तो नहीं कि बस ऐसे जनरल PI टाइप से करनी,
सब BC,
ऑल पार्टिसिपेट,
ऑल है पार्टिसिपेट। इसमें दूसरा एक इशू ये हुआ कि 2017 में रेगुलर वैकेंसी निकाले ये लोग 3080 वैकेंसी का, वो वैकेंसी क्रिएट होकर के न्यू वैकेंसी है। उस समय इन लोग सही परसेंटेज करके वैकेंसी निकाले। इनका कहना है कि OBC से BC2 से अवेलेबल था ही नहीं कैंडिडेट, मतलब दैट पोस्ट रिमेन अनफिल्ड। अब जब बैकलॉग का वैकेंसी निकाल रहे हैं उसी का, तो अब 0-0 कर दिए। हाउ कैन इट बी? इफ बैकलॉग वैकेंसीज आर बीइंग नोटिफाइड, तो एटलीस्ट एज पर द मेमोरेंडम इशूड बाय द गवर्नमेंट ऑफ इंडिया, यू हैव टू काउंट द वैकेंसीज एनुअल बेसिस पे। सो ये 2 इशू हम एक कंपाइलेशन।
रिटायर्ड लोग भी तो जो रिटायर करेंगे या जो भी हो सकते हैं, अभी तो लेकिन नया फ्रेश वैकेंसी।
आरके सबरवाल वाले मैटर का रिलेवेंस आएगा पहला एडवर्टाइजमेंट में। वहाँ पे ये कह भी रहे हैं इस तरह से, हालांकि हम लोग ये बोले हैं कि आप OBC काउंट कर लिए टोटल, तो वही आइए डाले थे कि यू शो टू द कोर्ट कि वो मेरिट पे क्वालिफाई नहीं किया था। अब आप बिहार से लेके अभी तक के टाइम का सारा OBC को ढूंढ करके पूरा गवर्नमेंट डिपार्टमेंट में कहिएगा कि नहीं ये भी OBC है, ये भी OBC है, ये भी OBC है, तो आप वैकेंसी घटा दिए। तो पहला एडवर्टाइजमेंट
तो डायरेक्ट अपॉइंटमेंट है ना?
एक तो डायरेक्ट अपॉइंटमेंट हो रहा, जो कि एनुअल होना चाहिए।
ये सारा का सारा डायरेक्ट अपॉइंटमेंट,
डायरेक्ट। एक बैकलॉग वाला है, सेकंड वैकेंसी जो 3000 वैकेंसी,
बैकलॉग भी तो डायरेक्ट अपॉइंटमेंट
डायरेक्ट है। हाँ, तो यहाँ पे ये कर दिए कि इनफैक्ट BC2 का पूरा वैकेंसी देखा जाएगा तो 0 हो गया, और कहीं कहीं 16 की जगह 2, कहीं 18 की जगह 3, हम एक कंपाइलेशन बना देते हैं।
आप इसको क्लैरिफाई किए हैं?
नहीं,
साइलेंस इज नॉट गोइंग टू बी अप्रूव्ड। साइलेंस से
let him complete. I'll place back.
नहीं,
We have
इसीलिए
tried to.
नहीं, जो
हमने तो
आइए
बोला
है
है,
6428 का रिस्पांस पूरा नहीं है मेरे हिसाब से, इसीलिए हम एट द आउटसेट
Learned counsel for the parties are present. The learned counsel for the petitioner submits that the recruitment process involved in the present case relates to advertisement number 2 of 2023 and advertisement number 3 of 2023. So far as advertisement number 2 of 23 is concerned, the same relates to fresh vacancies, and advertisement number 3 of 23 relates to backlog vacancies. He submits that the reservation roster with respect to BC2 category has not been followed in the present case. All the petitioners are candidates under BC2 category and have participated in the selection process. He submits that the learned counsel submits that he shall file a convenient compilation for consideration of this court. and also file a supplementary affidavit with regard to the present status of the recruitment process, and if the recruitment process is over, whether there are any vacancies available against the advertised post, particularly in BC2 category. मिल जाएगा आपको information?
सर मतलब एक चीज खाली अगर subjective लॉस मतलब my contention is that issues raised in 6428 was IA has not been responded to.
He has also submitted that the issues raised in IA number 6428
Of 2023.
of 2023 has not been properly responded to by the learned counsel by the respondents, although a reply has been filed.
But
देख लीजिए भाई,
we'll verify.
छोटा छुट्टा उट्टा हो तो उसको टाल दीजिए। अब छुट्टी बाद रख देते हैं। बताइए।
As you watch it, 1 week will be enough.
18 जून 18 जून छुट्टी के पहले नहीं हो पाएगा। 18/6
18/6.
Item 30, the request 2149 of 2020.
Which matter?
PC matter, petitioner important. All are the PC2 category, all are the
Allow
PC2
31.
matter this.
किसमें?
Is serial number 28.
आपको पिटिशनर नहीं बना सकते, इंटरवीनर को पिटिशनर नहीं बना सकते, आपको अलग से अपना वेरीफाई करना। आईए नंबर
2908
2908
and IA number 3044.
44 of 23
24.
of 24। देखिए आईए नंबर उसी प्रीवियस रिकॉर्ड में आईए नंबर 2908 of 24 and 3044 of 24। Madam, is that correct? They have filed intervention. The counsel for the intervener submits that the intervener petitioners are also belonging to BC2 category, and they may be added as co-petitioner in the present case. They are supporting the case of the petitioners. This court is of the considered view that interveners in the aforesaid interlocutory application cannot be permitted to be added as co-petitioner, as every petitioner has to give appropriate pleadings in connection with this case. Accordingly, IA number such and such are dismissed. The liberty is reserved with the interveners to take appropriate steps in accordance with it.
Foreign interview 3019.
3019 कौन है उसमें? 3019 इंटरवेंशन आपने फाइल किया, किसकी तरफ से? To be made petitioners, same order, वो भी same order
3019.
3019।
Item 30. Along with item 31 to 33.
Who is for the petitioner?
The petitioner, Your Lordship, he was assassinated while posted as a sub-inspector, for which we have filed a substitution petition being IA number 10135 of 2023, wherein we have prayed that her name may be substituted in place of the present petitioner.
ये कहाँ assassination हो गया भाई? Very unfortunate.
Yes, Your Lordship, he was murdered while in service as a sub-inspector, Your Lordship.
The learned counsel for the parties are present. IA number 10135 of 23. Counsel for the petitioner submits that the petition has been filed for substitution of the petitioner who expired while in service. Who was killed while in service.
Yes, on 14/8/23.
On 14/8/23, he submits that the substitution has been filed by the legal representative of the petitioner, who is the wife. A wakalatnama has also been filed along with the interlocutory application. The learned counsel for the respondents has no serious objection to the prayer for substitution. After hearing the counsel for the parties, IA number 10135 of 23 is allowed, and the petitioner, the counsel for this petition is being allowed only for the purposes of legal representation on behalf of the petitioner, so that the case may be pursued, and it is only for the purposes of the present writ petition and no more. The counsel for the petitioner is directed to carry out the necessary amendments in the cause title in reading during the course of the day. और आगे क्या है?
Your Lordship, he was not promoted to the post of inspector, although his juniors have been promoted, Your Lordship. Please just have a look to the rejoinder.
Why was he not posted? Why was he not promoted?
That they have stated in their counter affidavit, Your Lordship.
Any departmental proceeding pending?
No, Your Lordship. There was a departmental proceeding, but only the punishment which was imposed, that I have stated, censure, and censure will not affect the promotional right of the persons, Your Lordship. Please just have a look to my.
When is the junior promoted?
Yes, Your Lordship, please just have a look to the rejoinder that he has signed. Although they have stated in their counter affidavit, we have answered at paragraph 7 of the rejoinder. Paragraph 7, we have stated, Your Lordship, that before delving into the merits of the case, it will be suffice to categorically state before this Honorable Court that the statement made in paragraph number 7D of the counter affidavit is completely done to mislead this Honorable Court, inasmuch as it is stated that in the unreserved category, junior to the petitioner, namely Sangeeta, whose name appears at serial number 647, has been granted promotion by the police headquarters by memo number 1197 dated 2011-2020. However, to this it is categorically stated by the present deponent that not only Sangeeta, whose name appears at serial number 647, that is much below to that of the petitioner, whose name appears at serial number 74, merit number 636, but other juniors, namely, I have given the names of, Your Lordship, 28 persons.
What is the reason for not granting him promotion?
This was done by a system of pick and choose, Your Lordship.
Let us see.
Well, in fact, the departmental proceeding was one of the
It was pending or the punishment was imposed?
punishment. Yeah.
Your Ladyship, it was initiated and petitioner was seeking explanation in this, and it was awarded the punishment of 1 censure. You have already stated in
When prior to consideration of
first
DPC?
his name was considered, Your Ladyship. In para A, page 6 of our counter affidavit, we have mentioned that his name was recommended by for promotion by DIG, Your Ladyship, Dumka, in the year 28/5/2020.
Yes.
Annexure A, Your Ladyship, we have annexed the document.
Yes.
Page 29, his name has been flashing there.
Then
After that, Your Ladyship, it has been submitted that the petitioner has been suspended in departmental proceeding under the in 2/7/2020, and it was departmental proceeding was initiated, and for that he was not granted promotion, and then he was holding guilty of the charges and awarded the punishment of 1 censure, Your Ladyship. That was happened on 5/9/2020. That is the annexure C.
what is the consequence of censure?
Your Ladyship,
On the day his case was considered for promotion, there was no punishment.
there was no punishment.
Subsequently, the punishment has been imposed of censure. What is the consequence of censure?
In that consequences of censure, Your Ladyship, निलंबित अवधि में जो मिल चुका है, इसके अतिरिक्त कुछ भी
Promotion में क्या होगा? Censure का consequence promotion में क्या होगा?
Your Ladyship, in that
Suppose there is censure against somebody. How long the impact exists and what is the consequence? Is he debarred from promotion?
is debarred from promotion, Your Ladyship.
Under what provision of law, can you tell us? And that too, a censure imposed after his promotion was recommended.
It was stopped because of that only, Your Ladyship.
Can you do that?
For the award for the punishment only, the promotion has been.
After the matter is cleared from DPC, can you do that? On the date of consideration, there was nothing against him, right? He was recommended, then suspended, then some proceeding. When was the junior promoted?
Yes, Your Lordship, please allow me only to point out two relevant
2011, 2020,
20.
right?
And please just have a look to my rejoinder, paragraph 15 and 16. What is the effect of censure?
We'll hear it further day after tomorrow.
And only because he has passed away, Your Lordship, now only the promotion is to be given from that day. And
Provided
with an encounter
you
with the
examine
Naxalites.
this. Okay, counsel for the parties are present. Counsel for the so far as main writ petition, the writ का number डाल दीजिए.
Your Ladyship, I'm appearing in 2 cases, Your Ladyship.
Both?
Either 30 and 33.
Okay.
All the 4 cases may be put up.
Yes,
There
all are with, I suppose.
There are all.
Tag matters.
all-
I'm appearing in 2 cases, and other.
In all the cases, the
30, 31, 32, 33. Promotion from the post of sub-inspector to the post of
that's right.
inspector.
In all the cases, there was departmental proceeding.
No, Your Lordship, not in all cases. But
So every case must be having a different reason to deny promotion.
Denied promotion, yes, Your Ladyship.
But for this censure is only in one of the cases.
in this case only.
In other cases, what
No.
is the reason in other cases?
In other one more case.
अरे भाई इसका थोड़ा
No,
नोट
no,
बनाइए ऐसे
altogether,
कैसे?
no, altogether 26 candidate promotion was kept in pending due to department proceeding.
Including all these 4 persons.
I am appearing in one.
Your Lordship has already held, even if there is a departmental proceeding.
That is not a reason for.
No, and
denying.
secondly, those posts have to remain vacant, and in a sealed cover procedure, it has to be allowed. Your
Janki
Lordships
Raman.
have allowed.
Janki Raman.
Janki Raman. And in 724 and 726, it is the same case. Now, Your Lordship, what has happened? They have in their counter affidavit stated that there are 606 sanctioned posts, and they have already given promotion to 629, more than the sanctioned post. And as far as these persons are concerned, and what is the reason for only giving promotion to 21 people, not 22 or to 60, that is for them to say. And in the last order, Your Lordship, may please just have a look to this order. Your
आप
Lordship.
सुन रहे हैं क्या क्या बोल रहे हैं?
No, they have stated in their own counter affidavit. Your Lordship will please see. And on the basis of this order, Your Lordship may please. Immediately they gave promotion to that petitioner because of this. Yes. जो हम serial number 15 में आज था. Please just have a look to paragraph 2.
जो आपने आज विड्रॉ कर लिया।
जी, क्योंकि ये लोग 21 आदमी को ज्यादा दे चुके हैं।
इनको भी दे दीजिए।
And now 73 posts are vacant now. They have all been promoted to.
ठीक। Day after tomorrow रख थोड़ा सा चार्ट बनाइए किसका क्या क्या पेंडिंग था और कब से पेंडिंग था, पनिशमेंट कब हुआ और सेंसर का क्या इम्पैक्ट है। मैडम यू गेट जजमेंट्स, आपका मतलब लेक्चर से नहीं चलेगा। यू शो द प्रोविजन ऑफ लॉ, व्हाट इज द इम्पैक्ट ऑफ सेंसर, और दैट टू अ सेंसर imposed after DPC, whether the promotion can be stopped on account of such a censor. ठीक है।
And in the rejoinder we have stated at paragraph 15 and 16.
बताएं।
Censure cannot withhold promotion.
Day after